Numbers 6 and 7. I have 223-0007108. Catherine Moses, represented by Ms. McLean, who is present, and Jason Moses, represented by Mr. Zandy. I also see Ms. Height present. Good afternoon, folks. This also is a case with quite the history. I have reviewed it. My understanding is that there are motions to amend orders.
That's correct, Judge. Both parties filed a motion. Ms. McLean and I have been in communication regarding these issues for the better part of the last 2 months. My client filed his motion, I believe, on November 3rd, and we got Ms. Moses' counter motion a day or so later. So I don't know who you want to hear from first, but I think both sides are prepared to make argument.
Okay. So let me just ask before we get started, because I think it kind of pertains to the case in total. Has Mr. Moses undergone any of the treatment that was ordered by the court eons ago?
Yes, he's doing that. So you saw a copy of the report from Dr. Johnson subsequent to that and after that. He gives you in his declaration the services that he's been seeking out, that being the certified sex addiction therapist. Tyler Chin has also worked with the Integrity Group. And then most currently he is working with Ms. Lovely. So on further evaluation. So not much more from our perspective he can do. That remains in process. I did speak with Miss Lovely a week or two ago about that. She informs that she's ready to go working on that, has been a little bit behind in things. Not pertaining to Jason, but I think like most therapists is quite busy and inundated right now, was I believe what she stated to me. So he's working the process, he's doing what he can. Yeah, pending more information.
Okay.
So if I could just
go ahead
on that. So first off, I'm not aware of Mr. Moses participating in a psychological evaluation. I'm not aware that Ms. Lovely, who I think is a master's level practitioner, is qualified to do a psychological evaluation. This is the first I've heard that he's ever reached out to her. We have a court order that indicated that the prior evaluation with Dr. Johnson did not address the issues that the court had ordered him to address. And for the first time in Mr. Moses's reply declaration, we're told that he has been meeting with this Mr. Chin and somebody else for over a year and a half, information that was not disclosed to the guardian ad litem, information that's not been disclosed to us. We have received absolutely nothing.
Okay. So let's do this. And I know Ms. Height, I'm sure you have some input here.
I did file a brief reply. Did Your Honor have a chance to see that?
Just a sec. Hold on. I have a judicial assistant here, and then I will get right back to you. Okay, Ms. Height, thank you.
I filed some information for the court on the 15th. And I did a copy as well. My thoughts and conclusions are in there. I did not know about any further treatment that Mr. Moses was seeking at the time that he and I talked. And I do know that he has had a history of working on this problem over time, but I don't know of anything freshly that's been mentioned today as far as treatment goes.
Okay. So let's do this. I think because if I recall correctly, Mr. Moses's motion was filed first, and then Ms. Moses filed her motion. Let's hear from respondent first.
Okay. And thank you, Your Honors. The court is aware I do represent the moving party to the first motion in front of you. Namely Jason Moses. And again, from a timing element, I seem to point out my client does file his motion, makes various requests contained therein, and I would say they're relatively minor. the relative tweaks to the existing order, which has been in place for some time. There's been no issues with the kids, contrary to what Ms. Moses parlayed in front of the court in anticipation of this hearing. My client details for you his time with the boys has gone exceptionally well. Both kids, that's Braxton and Lincoln, and I know you're going to hear conflicting information from Ms. McLean on that. My client details for you once Lincoln is in the car with him, things are well. I would certainly start by noting that this is unfortunately a case, and I think your take on this was correct, that has been bogged down somewhat with evaluations, with treatment options, with allegations. We now have the new one that mom raised a couple of weeks ago in her submissions, all of which are aimed to curtail my client's relationship with these boys. And again, throughout history, my client has been very involved with these kids. These kids love their dad loves them. He takes very good care of them. And despite the allegations of mom from this pornography addiction from 8 years ago or so, a lot of that, again, has somewhat come out through the GAL investigation, the report from Dr. Johnson, the evaluations of the ongoing treatment that my client has undergone. And again, you asked an important question at the onset. Now, what's he currently doing now? I don't know that he's ever stopped with a lot of his treatment. I think this is constantly something that he's been working on. He's taken accountability for that. If you went back to the initial stages of this case, again, you'll see he's never shied away from that. This is something that has been addressed. And this is something that Ms. Moses, again, continues to hearken back to time and time again as a related issue. And since the separation, it hasn't been a problem. That's first and foremost. We look at where we're at now. You have obvious attempts of one parent who is trying to alienate the other. I think if we look at the facts of this and the timeline, again, my client files his motion in early November. All of a sudden, the allegations and his problems from Ms. Moses rise from, well, he's got pornography issues, to now he's inappropriately touching one of our children, the younger child, in a public setting at a soccer game in front of 250 people at 7th Avenue Park, which is directly observed from grandma and a babysitter that nobody does anything about. Nobody relays that to the authorities. Nobody raises that to their attorney. We don't find out about it again until we get her responsive pleadings. And then all of a sudden, it's this major issue. I think it's absolutely deplorable to make that allegation without any kind of substance to that, to just say, well, Jason has now filed as a father who wants very basic request to increase time. I'm now going to raise the stakes, up the ante a little bit, and claim that he is somehow molesting or inappropriately touching our child at a soccer game in front of 250 people in purview of grandma and babysitter, which again are strictly aligned with mom, who filed declarations 3 weeks later and say, well, we essentially didn't really know what to do, but conveniently here on the verge of litigation, here you go. I think he was inappropriately touching the child. Again, given the context of this, and given the history of this case, given the obvious attempts, which can only be classified as alienation, given the obvious attempts of mom to disrupt the relationship between dad and the boys, and she's done a very good job of that so far. She now, again, pushes all of her chips in and says, well, now not only does he have pornography issues that extend for years past, but he's also a danger to the children. That's problematic. And fortunately, that is kind of the tone and the tenor of this case. It has been from the onset. But my client was very surprised to review that. He was disheartened to review that. And again, when you look at it from the context of these kids, what is mom putting the kids through on this? I'll get to that in a moment. We look at my client's specific request related to midweek visits. Again, this is a pretty standard parenting plan. This is one where my client enjoys the children every other weekend. Also has a midweek visit, which traditionally has been on Wednesday for several hours, so from 4 o'clock to about 6:30. Oftentimes during those visits, and it's been every week, oftentimes in those visits, it involves going to soccer games and extracurricular sporting events for these kids. That's great. My client has done that. But while he's on the sideline watching the kids, which he loves to do, it does take away from his time with the children. Most recently, and again, leading to the filing of this motion, it was reviewed, and somehow in the order that was entered about this time last year, that Wednesday visit was not included there. Parties continued to exercise that Wednesday visit. So my client had contact with both children every single Wednesday, but somehow through a scrivener's error or through some unforeseen circumstance, nonetheless, the order wasn't reflected as that. My clients had them every Wednesday. It was by agreement of the parties. Most recently, mom becomes aware of that and says, well, the order says you don't get every Wednesday, and therefore I'm taking one of those away. So the request today is this. So we are asking that you order specifically one of two things. Number one, that my client have 2 midweek visits every Tuesday and Thursday. Basis for that request is the fact that, again, these kids are involved in extracurricular activities. My client would like to attend their games, which he does, would like to attend and have activities with them outside of sports in the soccer fields, which is why we're asking that you modify that and bump that a couple hours a week, make it 2 times per week as opposed to 1 every other week. Alternatively, we're asking that you, if the court doesn't want to make that jump, especially given the most recent allegation, we're asking that you recognize the agreement of these parties, the status quo that has been in effect for the past year, that my client have every Wednesday with these boys from 4 o'clock until 7. That will give him an extra half an hour. That will allow him to take the boys to the park or take them to dinner and again, maintain that relationship. As I mentioned in my prior comments, and again, this goes back to and dovetails with some of these alienation type behaviors. It's interesting that my client details for you in his initial declaration the fact that when it's, quote unquote, not his Wednesday and he goes to the soccer field or he goes to participate in one of these functions with the boys, what does the mother do? Mom tells the other child, go sit with grandma and grandpa. It's not daddy's time. You hang out with them, and it strictly informs my client it's not your time. Essentially, go stand by yourself and watch whatever the participating child is from a distance. Again, that is a sign of major control issues. We also have this issue, which my client details for you, related to the Great Wolf Lodge and the birthday parties. Again, my client plans a surprise trip to Great Wolf Lodge for these boys, has confirmed that that's set to go, starts getting messages from Mrs. Moses saying, well, the boys need to go to a friend's birthday party on a Saturday afternoon, I believe it was. Starts putting pressure on him for that. My client says he's had other plans. Again, it's his time under the parenting plan. And what does mom do? Mom directly involves the children, telling them, dad won't let you go. Take it up with your dad. Kids end up going to Great Wolf Lodge. They have a great time. It all works out good. But again, this is further evidence of what type of situation and conflict we're having with mom at home and these kids. This is now showing itself. And the second request is that we change the exchange location provision currently. It parlays itself in these exchanges. Everybody agrees Lincoln is torn at these exchanges. This child, again, is working with Ms. Rosen. These parties are participating in some capacity with the family counseling with Miss Rosen. But what do we see? We have mom who says Lincoln doesn't want to go with dad. Now, Lincoln is reluctant to go with dad. He doesn't want to get out of the car. My client readily confirms that. He says there's clearly some kind of a loyalty divide. Lincoln, who again is a pleaser, doesn't want to upset mom. Lincoln is now being, unfortunately, and it's a terrible analogy, but in a tug of war with loving both parents. Both parents love him, but he wants to please both parents, and that's at odds with the circumstances. Lincoln eventually gets in my client's car, and for the weekend, he's great. There are no issues. Again, there's nothing in the counseling records. I'll let Ms. Height speak specifically to that. I don't see anything in her report that suggests Lincoln is in any way in harm or in distress with dad. In fact, the information is contrary to that. What does my client tell you? There are no issues with it, and Lincoln is good. Braxton is good. What does Braxton do? He asks his dad. He says, Daddy, how many days until I get to see you again? That is not information from a child. And again, I would object to the child hearsay that's permeates throughout Mrs. Moses's declaration. That is not the communication from a child who is showing distress. That's the communication of a child who wants to spend more time with dad because the child misses dad and loves dad just in the same capacity as the child misses and loves mom. And that's a good thing. The unfortunate thing we have right now is the children are, again, in the midst of this conflict between the parents and feel a loyalty, at least one of them, to mother. And mother is not helping that situation by, again, putting them in that circumstance. And the latest allegation doesn't help. That's what we're asking for in regards to the exchange location, simply that it be changed from a neutral site to door. Again, the parents can get the kids out, exchange the parents. I think that makes sense. Now, that's our second request. Third, and it sounds like it's agreed, related to this family counseling, as I noted, parties are participating with Charlotte Rosen. It sounds like that is obviously happening. There's been some hiccups along the way. Both sides attribute blame to the other. Nonetheless, where we are today is it's going well, and we continue to work through that process, and that's a positive thing. Simply asking that be reduced to order, and that both parties be required to participate in good faith and comply with the recommendations set forth by Ms. Rosen. Finally, and the last request is related to the holiday schedule. My client, since separating, has had very little holiday time with these boys. These boys love their extended family, love their time with dad, as I've noted. My client should be in a position to have extended time with these boys. That's what we're suggesting. Now, he hasn't enjoyed Thanksgiving with them, to the best of my knowledge, in some time. We are asking that he have this year from 10 a.m. On Thursday until 5 p.m. the following day. That gives him the opportunity to start new traditions. And again, that's healthy and it's appropriate, and it's certainly reasonable based on the history of this case. Also asking for some time over the winter break. My client is off the entire winter break, as he is a school teacher, and we're not asking to impinge on mom's time. Mom has her own traditions, and again, those are very valuable for the boys. What we're suggesting is simply an extended visit from December 26th at 10 a.m. until December 31st at 6 a.m. Kind of gives him some substance in between Christmas and New Year's, gives mom the benefit of having both Christmas Eve and Christmas Day and New Year's Day. And again, best interest of the kids, that certainly gels with the theory that they should enjoy both time with both mom and dad over the holidays. I can get into this, and I will very briefly, because again, in an effort to save time. This unfortunate incident at the soccer field, again, that goes unreported for 3 weeks, seems highly unlikely that a grandparent or a third party or one of the approximate 250 people that are in attendance would not have stepped in for the well-being of this little boy if they thought something was happening. They wouldn't have addressed it. Again, this is my client's ex-mother-in-law. Would not go over to him and say, I think that's inappropriate what you're doing with Lincoln. What more than likely happened from that? And again, we don't hear anything of it from 3 weeks later. My client gives you an explanation. I think certainly given the circumstances, it's likely, if not entirely, how that occurred. He sees his child, as he's done time and time again, even during the marriage, gives him a hug, gives him a little bit of a tickle on the ribs or the chest. Child is playful with dad. Child, again, as kids do, slap back, smile on his face the entire time. Child is put down. Child goes about playing with other kids. Nobody says anything to my client. And then 3 weeks later, again, barely one day after we file this motion and it's served on Ms. Moses, we get the allegation, again, that this case has now gone, unfortunately, nuclear. There's one thing worse than a child molester. It's somebody who accuses somebody else of molesting a child knowing they didn't do it. And again, given the facts of this case, given the circumstances of there being 200 plus witnesses at a soccer field to allege that my client, and this is where the Dr. Johnson report comes into play, where he says this man is of absolutely no danger to children, his or anybody else. To make that allegation, again, and the timeline and the circumstances it was, shows somebody who just desperately wants to maintain control of the family, somebody who has an axe to grind with their ex-husband. And unfortunately, that's the circumstance we're in now. So no wonder, given these allegations, no wonder, given this conflict, we have 2 kids, at least one of which is having significant issue getting out of the car and going back and forth. And that's the saddest part of this case. We need to stop treating my client like he's some kind of a danger to his kids, because if anything, he's the direct opposite of that. He's always been supportive. He's always been loving. He's always been nurturing. And there's absolutely nothing in the court record outside of his own admission that years ago he had an addiction to pornography, which again, I would argue, I still don't know what the impact on his kids is with that, that we are now riding this far now with the mushrooming allegations of that he's molesting or inappropriately touching his own kids. And that's a tragedy. It needs to stop. So we are asking you to grant the relief that we've requested. are asking again that the court make certain findings that is in the best interest of the kids and continue with the counseling. Everybody needs to do that. It's good for the kids. We'll get input when that time comes. But as for now, everything requested is reasonable. We're asking you to grant it in its entirety.
Thank you, Mr. Zandy. Okay, Ms. McLean.
Thank you very much. So we have filed a motion outlining the concerns that we have and requesting that visitation be reduced. Contrary to counsel's argument, he and I had a discussion about what the issues were, and that was memorialized in the email that was attached to my client's declarations. It was agreed that we would get motions filed without order shortening time and that we would set for today. So I guess let me start off first with the concerns as it relates to our request on limiting his visitation. Lincoln, the youngest child, is clearly reacting negatively on transportations for visits, in counseling, and just is overall, he's deteriorated. There is something that has happened in August to cause a substantial change in him. And it's not appropriate for parents to physically force a child to go on visitation. And to be quite honest, that places my client in a bad position of not being viewed as a safe person when she's the one that's having to physically get him out of her car. Mr. Moses is physically pulling this child off of her in an effort to get him to go. My client has been supportive of getting these boys to go. She's been there for visitations. She's here asking the court to recognize that there is something seriously wrong with this 6-year-old child. If you go back and look at the history of this case, Mr. Moses was ordered to participate in a psychological evaluation to address his sexual pornography addiction. He has never complied under the temporary parenting plan with that order that was entered over a year and a half ago. He says that, the parenting plan specifically indicates that his failure to comply with the evaluations and treatment is a basis for Ms. Moses to ask for a reduction in his visitation time. You have 2 children who have been in counseling with Charlotte Rosen, who's a very well-respected practitioner in our community. These children have been in counseling with Ms. Rosen not for a couple of months, as suggested by Mr. Moses, but for nearly 2 years that these children have been in counseling. That's a protracted period of time, and there have been ongoing concerns, and these were outlined through Ms. Rosen, through Ms. Height, as well as Ms. Rosen with counsel and I. The children, after these parties separated, started talking about a penis monster. The children, after these parties separated, started engaging in inappropriate self-gratification in public locations that even Ms. Rosen identified was inappropriate for them at their given ages. Now we have Lincoln negatively reacting to the visitations with Mr. Moses. And if you look at Ms. Rosen's email that we attached to my client's reply declaration that was sent out to both of these parties on November 8th, she says specifically that Lincoln has been, or that he's physically regressed, he's emotionally overwhelmed, and he's struggling to express his feelings. That does not align with Mr. Moses's claim that everything's hunky-dory at his home. We have Ms. Rosen, who has recommended child-directed phone calls. In other words, when the children ask to call, that then they should be allowed to call the other parent and to stop the parent-directed phone calls. Ms. Height's report that was filed in January of this year recommended child-focused phone calls, that the parent-directed phone calls were not serving the children well and not serving these parties well. Counsel and I have been in protracted attempts for the last 4 months to try and resolve that issue alone without success. You have Charlotte recommending that these parents participate in co-parent counseling, not family counseling. Mr. Moses is suggesting that he's willing to participate in family counseling with the children. That is not what Ms. Rosen is recommending. And even Ms. Height in her recommendation talked about Ms. Rosen's willingness to engage these parties in co-parent counseling. Again, for the last 4 months, we've attempted to try and get that entered so that we could have some teeth to get Mr. Moses to participate in that. He has not been willing to agree, and even today is not willing to agree, even though Ms. Rosen has recommended it as being in the best interest of the children, and Ms. Height has recommended that it would be in the best interest of the children. Ms. Rosen has recommended that screen time be eliminated altogether during Mr. Moses's time. And that is because of his lax rules and his normalization of the use of screen time during his residential time. Obviously, when you're talking about somebody who has a pornography addiction, a prior instance where the children actually accessed his pornography on, it was either the television or the computer during his residential time, that is something that we need to protect these children from. Ms. Rosen has expressed concerns over Mr. Moses's lack of honesty with her, his minimization of his addiction, the letter that he wrote to the boys before these parties started this litigation, where he acknowledged himself that he is a danger to his children and told his wife that if he relapsed, that she needed to withhold the children from him because he is a danger. That's his educated statement of his own addiction, that he recognizes he's a danger to his children. And you also have information about, again, because of this co-parent counseling recommendation, of how poorly he treats Ms. Moses in front of the children. Totally contrary to the narrative that they're attempting to spin. This is not a healthy parent-child relationship, and he has done nothing, absolutely nothing. You have nothing in written declarations from practitioners, in evaluations, in class participation. There is not one shred of physical documentary evidence and no disclosures to Ms. Rosen or to Ms. Height that he's participated in any type of counseling. And when you go back and look at his prior declarations that have been submitted with the court, he denies. He even told Ms. Height that he automatically quit looking at pornography. And even in her guardian ad litem report and recommendation, she says that's highly unlikely that he is able to stop cold turkey when he has not been able to be successful after historical repeated treatments and interventions. Mr. Moses is a self-declared 30-year pornography addict. Ms. Height outlines in her guardian ad litem report for you about the, and this sort of dovetails into Mr. Zandy's argument that he has no idea what this has to do with the negative impact on his children. Ms. Height sets it out. She says, available credible research shows that the viewing of pornography, whether one considers it an addiction, compulsion, or an innocent pastime, creates anatomical and pathological changes in the brain, which result in various manifestations of cerebral dysfunction, collectively labeled hypofrontal syndrome. In its simplest terms, it creates damage to the braking system of the brain, allowing riskier behavior while in search of repeated pleasure. This is an individual who, according to the witnesses that Ms. Height believed their credibility when she talked to them about what they observed, said that he put his hand under this child's coat, touched him, or basically kneaded his hand or palm into the groin area of this child or the lower belly of this child. The child's reaction was not to laugh. The child's reaction was startled. The child grabbed his arm, didn't push it away as he suggests, And now you have Mr. Moses saying that, well, I came up to him, I tickled his rib cage. That's a significant difference for him to say rib cage versus the lower groin area. Couple that with the good talk, bad or good touch, bad touch discussion that Ms. Moses engaged in with the child when he disclosed that his dad does touch him between his belly button and his penis. You have multiple examples that my client outlined in her declaration of Mr. Moses talking out of both sides of his mouth and making contrary statements to Dr. Johnson versus what he's told this court. You have Commissioner Cotterell, who basically in open court chastised Mr. Moses for not being honest with this court, for being cavalier about his sexual addiction. And at that time, Commissioner Cotterell denied Mr. Moses's request to allow for holiday time or extended residential time. You have Ms. Height's guardian ad litem report in January that says maintain the status quo, no extended time. And again, her recommendation is this alternating Wednesday, essentially, not every Wednesday. For counsel to suggest that there's a Scrivener's error, I'm sorry, Mr. Zandy's been practicing for a long time. He knows exactly how to file objections with the court on orders. We've had multiple discussions about the fact that, yes, the parties have mistakenly been exercising or allowing Mr. Moses to exercise every Wednesday when the plain language of the order was that his Wednesdays were supposed to be after his weekends, which essentially is every other. To suggest that that's a Scrivener's error, he hasn't filed a motion on that. They haven't filed a motion for revision on Commissioner Cotterell's denial of holiday time or finding that he has not complied and that Dr. Johnson's evaluation does not comply with this court order. You have an individual who's basically skating. He's skating under the requirements of this court. He's come before this court and asked for additional time. And you have this child counselor for Lincoln saying this child is presenting horribly, and so much so that I'm now going to double up his counseling. Mr. Moses is not being honest with this court. We are asking that the court reduce his visitation time. We're asking that the court provide for the alternating Wednesday visits, that the court provide for the first, third, and fifth weekends defined by Fridays on Saturdays from 10 a.m. to 6 p.m. We're asking that the court deny any extended holiday residential time. We're asking that the court remove the parent-directed phone calls and go to the child-directed phone calls that were recommended by Ms. Rosen and recommended by Ms. Height. We're asking the court to order Mr. Moses to participate in the co-parent counseling that is recommended by Ms. Rosen and recommended by Ms. Height. We're asking the court to maintain the visitation exchanges at the Shell station in Castle Rock. My client does not want him at the house. She does not want to go to his house. They've been, by agreement, exchanging at the Shell. It's equidistant between their residents. I'm not sure how you fashion that, he needs to allow for these children to participate in peer functions. The argument is that, well, he goes to the soccer games on Wednesdays, but that interferes with his visitation time. I'm sorry, I thought part of parenting was exposing your children to events and showing them that you're supporting them in those events. It's not what is the gratification that you're going to get on one-on-one time. It is supporting your child. That's what parents do. We're asking the court to enter an order to stop all screen time during his residential time. Counsel says that once, and I'm just going to go down my notes that I was taking while Mr. Zandy was making his arguments. He says that once Lincoln's in the car, things are going well. Again, that's not supported by how Lincoln's presenting in counseling. That's not supported by the concerns that Braxton has raised and what he's indicated.
Again, we're getting I've let it go. We're getting way far afield of what's in the declarations, and there's obviously child hearsay that's trying to be admitted once again. So I'd object to on both those bases.
Yeah,
And I would,
I'm going to sustain that. I think we are getting a little bit far outside the declarations because some of these requests are a little surprising to me. I do have the declarations and the proposed parenting plans in front of me. So, Ms. McLean, what are the final requests? And then I'm going to move on to Ms. Height.
we've provided those requests.
Okay, thank you. Ms. Height, and I understand that you did submit the November 15th report after review specifically of this alleged incident between father and son. I have read your recommendation. There are several recommendations in there that you're offering to the parties, but in essence, I take your opinion to be that maintaining status quo for the time being is in the child's best interest. But I'll turn it over to you to elaborate on that.
That, Your Honor, is where I landed. After speaking with Miss Rosen, I kind of deferred to her concerns. They were quite dramatic, and I felt like we needed more information from her before some other action was taken. I believe there's a lot going on. I would also like Your Honor to know that when I spoke with these parties, both were cooperative, both obviously care for these boys and want what's best for them. There's a big disparity, but that is one thing that is obvious from my conversations with both of them. When I spoke with the witnesses to the event at the soccer field, both were very sincere. I believe that the reports they made were in good faith. I don't think there was anything manipulative or nefarious about what they were reporting to me. However, I was unable to come to an agreement that is what happened, mostly due to the fact that it seemed unlikely, as I reported and as I put in my report, if I believed that there was molesting going on to those children, frankly, Your Honor, I would have requested supervised visitation. I think it is, if that is occurring and it is occurring in public, it's of such a concern that I wouldn't be comfortable otherwise. I feel like there's some difference between what was told me by both parties, and I could not come to an agreement in my own mind beyond that. So I don't like to be left there, but there basically was a he said, she said. I couldn't rewind the tape and watch it for myself as there's no tape. So in addition to that, I would not characterize what's going on with the boys, particularly with Lincoln, as a hiccup. I think that there's something that is quite troubling. And I believe also, it hasn't been brought up here, but I think that Braxton is struggling as well. I think his struggles come out differently. Several people reported to me, including Miss Rosen, that Braxton's way of dealing with things is to close himself off with a book, and that he's doing that more and more. So my concern is for Lincoln. My concern is also for Braxton. And I think until we can figure out what is at the basis of that, I just could not get to a comfortable place to recommend any changes. I am specifically troubled by the idea of them having twice as many exchanges. I think doing this twice a week on a Tuesday and Thursday is a recipe for just more distress at the present time until what's really going on can be figured out. So basically, I'm stepping away, wringing my hands, wishing that I had more information for the court. But in good conscience, that's where I could land, Your Honor.
May I ask a question?
Go ahead.
Ms. Height. So when you say status quo and going back to your final GAL report, what is your position on Wednesdays? As you know, they've been exercising every Wednesday. Your recommendation, and technically the temporary order, was for essentially alternating Wednesdays or the Wednesdays after his weekend visits. What is your recommendation on Wednesdays?
I did not realize they were every Wednesday until very recently. So my idea of status quo is is every other Wednesday at this time.
Yeah, I guess my point to that or counter question would be if there's issues with the phone calls, and again, that's a complete swearing match as to what's going on with those. Wouldn't the addition of an extra Wednesday take away the phone call problems that we're currently experiencing? So it could theoretically be beneficial.
I'm sorry, are you addressing me, Mr. Zandy?
If you've got a good answer for that, absolutely. Yeah, yes. I was intending for you to answer that because the phone calls have been an issue. I think we all agree to that. If we allow another midweek visit, as they've been doing for the better part of a year, does that in any way impact the negative impact of a phone visit or some of those? Does it alleviate some of those concerns?
Well, nobody is going to appreciate my answer. I don't know. I'm not a big fan of tying kids into a scheduled visit at this age, a phone visit. I just think they're a little bit invasive, and when the kids can make a phone call at their convenience and tell mom or dad something happy that happened, I'm all in favor of that. I just think that when they are legislated, it makes it tougher on everyone, including the kids.
Get extra visitation in person with dad and the boys would be more beneficial than the phone calls.
I'm not prepared to answer that. I don't know.
Okay, fair enough. Thank you.
Thank you. Okay, Mr. Zandy, any short additional reply you want to make?
Yeah, and I'm going to rest largely on my client's reply because there is an answer to almost all of that. I will take the easy ones, which, and again, you got kind of the hint that I was making with Miss Height. I think if we give my client the one-on-one time with both the boys, again, Braxton, who wants to do that, I think that's beneficial. We can then take away some of those phone calls, which have been problematic for the last several months. That's first and foremost. I would also point out again, and whether these witnesses are credible or not, they are biased. They strictly align with mother. I would hope that if we walked into a grocery store, we were at a soccer game and we saw a 6-year-old with some grown man's hands in his pants and his groin tickling him, somebody out of 250 people that were witnessing that, especially a grandparent and a babysitter, would step in and say, hey, that's inappropriate. So if we look at that logically or reasonably, you're not going to sit around and wait for 3 weeks and say, we really didn't know what to do. And oh, by the way, there's a pending motion that was just filed yesterday. So now let's bring that allegation forward. That just flies in the sense of reason. So that's kind of where we're at. And counsel is very quick to appoint blame for Lincoln on my client. That's been kind of the theory and of their case from the onset, and somehow it relates to this porn addiction from years ago. The letter she cites is from years ago. That's when my client was trying to salvage the marriage and they were still in a relationship. So again, the weight of that letter should be given what it's worth, which is very, very little. And my client, again, has addressed that in prior hearings. So looking at the information from Ms. Rosen, looking at the information from Ms. Height, I think it's fair to assume, and the one thing we agree to is yes, Lincoln is struggling at the exchanges right now. What we don't agree to is what is the root cause of that. And we don't know at this point. And again, my client gives you his position on that. It's logically and reasonably based. Mrs. Moses gives you her impression of that. And again, I think that doesn't hold a lot of water when we're looking at the circumstances of this matter. But again, these boys need both parents. I think it's obvious both parents love these kids. They have diametrically opposed positions and views related to that. I think everybody wants to work together to make sure that those kids' interests are being fostered. And that's what we need to strive towards, instead of having allegations of mud being thrown, especially in the nuclear capacity as we're currently facing. We do need to go to counseling. I'm confused by counsel's suggestion that my client is unwilling to do that, when that is the very request that is in my client's initial motion that they responded to. So yes, let's pursue the family counseling, the co-parenting counseling, whatever you want to call it. My client, Jason, nod your head or shake your head. Are you on board with that? He's on board with that as suggested in our motion. So as far as going back and forth with this, again, we're spending a lot of time and effort pointing fingers, when what we need to do is figure out what these boys need and work to accommodate that. That's where we are. That's what needs to happen. And making the allegation that one parent who is involved in loving and nurturing and cares for these kids put his hand under the little boy's pants at a soccer game is completely inappropriate, and that flies in the face of what we should be trying to accomplish right now.
Okay. All right. Thank you to both councils. Thank you to both parties for being present. Ms. Height, thank you for your input and report. I am going to rule as follows. And the basis for my ruling is rooted in, I think what both parties have acknowledged on some level is, I don't think now is the time. Well, I know now is not the time for massive change in what is currently happening. And I mean that in a sense of, I understand there's an order hanging out there that could be or is construed to mean that visitation should be every other Wednesday. But in reality, what these boys have been experiencing and what the parties have acquiesced to for quite some time is visitation with father every Wednesday. So I would like that memorialized in an order, that visitation with father is to continue occurring every Wednesday. Again, every decision I make here today is going to be rooted in, now is not the time for major change for these boys. I don't believe that I have enough evidence in front of me to say that the allegations of some sort of abuse of one boy has occurred. More likely than not. I don't have any CPS documentation. There's no police involvement. I tend to agree with, I think, what's in Ms. Height's report, that I guess I would be shocked to believe something like this would be occurring in broad daylight in a scenario where there's been no concerns raised at any time during the pendency of this action. That yes, there might have been discussion previously of porn addiction. That's a very separate and distinct thing from touching your own children. So I don't put weight in that. I'm not making any changes to the parenting plan based on that. I do have to, however, take into account that just in April, a judicial officer did deny a similar request regarding to extending holiday visits. I'm going to again decline to extend holiday visitation until we have more input from Ms. Rosen. And again, going back to kind of my mantra for my entire decision today, it's, I don't think now's the time for significant change. I'm going to keep the exchange point as the Shell station. I'm not sure that that is working, to be fair, but I also don't believe mandating that the parents show up at each other's homes is going to be more appropriate. I would recommend that the parties maybe utilize some of the recommendations that Ms. Height has, as far as some positive reinforcement for transferring between parents. Let's see where we left off. I obviously want included in the order to follow co-parent counseling / family counseling as recommended by the counselor. I also believe the counselor is recommending that we increase visitation with, or not visitation, excuse me, counseling with Lincoln to, is it 2 times per week? I don't think
1 time per week.
Oh, 1 time per week. Okay. So again, I think we can be generic and say, I would like the parents to make sure the children are following the counselor's recommendations. It seems like that's agreed to anyway. The phone calls, it sounds like there's a request to change that. Is it, I mean, here, I guess my bias will show a little bit on children's phone calls, and Ms. Height kind of touched on this. You know, I'm a big fan of child-led phone calls. I think it's one of the things that children still maintain control over when parents are separated. Everything else is being dictated for them, when they can see the parent, when they can't see the parent, who they get to be with. But I think any child going through this should be able to tell and feel safe to tell their residential parent at the time, I would like to talk to mom, or I would like to talk to dad. And I really would like to see that happen in this scenario. Obviously, go ahead, Mr. Sandy.
Sorry, I didn't mean to interrupt. I thought that was a little, we're in agreement to that. We would just ask that the provision that neither parent interfere with the children's right to do that be included in that order.
Please do so, include that.
And so I'm assuming then that you're going to terminate his court-ordered telephone calls?
Yes, I am not going to court order telephone calls. And when I talk about child-led phone calls, I also take that to mean if there's a day that a child doesn't feel like calling the other parent when they're not with them because that's just how the day is going, that's also okay. I wouldn't like to see there be no contact for 3, 4, 5 days. And I think both of you are, being the adults in the room, would probably encourage your child to reach out to the other parent to maintain that relationship. So I hope that is happening. But like Ms. Height said, I think that there are some parts of this whole process where we need to, especially boys who are older, they're not toddlers anymore, letting them have some say in when they talk to their parent, I think is really important. I'm just going through my list here. So weekly, every Wednesday, we talked about family counseling. We talked about the exchange location, holidays. I would like to set a review date where Lincoln, in particular, has had a chance to undergo some additional counseling to see if there are additional recommendations that the counselor has, perhaps with drop-off locations and holiday schedule. So I'm proposing maybe a 60-day review unless folks think that's too long, but I think that gives us some time for some counseling with child to be undertaken, but I'm open to that date.
60 is fine. I'm thinking actually 60 might not be long enough, but council and Ms. Height, I think, can accommodate that as necessary, the dates.
Okay. Do you want me to set a date or do you all want to note it on?
Yeah, I think setting a date just to keep it tracked is probably a good thing.
Okay. And you all probably know better than I, in 2024, will represented docket still be Tuesdays at 1?
Yes.
Yeah. Okay.
So
You're
February
Let's do
February 6th.
Yeah, let's do February. I have 27.
February. Oh, I thought, did you say?
Oh, I'm
60 days?
sorry. I went a whole month ahead. I put you 3 months out. Thank you. January. Nope.
What about February 6th?
Let's do February 6th. That sounds great. And then those were my notes, but am I missing a request that either party has made that you want me to rule on before you put that order together?
Screen time.
Not from in Judge, just a presentation. Do you want us to put that on a pro se docket, or what's your preference on that?
Let's do, you could put it on a Wednesday pro se as long as it's done before the end of the year, because then they're taking me off of that.
I think council, I could probably craft the order with that input. I think that's pretty clear, but just in case, can we put it on Wednesday, December 6th?
Yes, that will work for me.
And that's
The
at
6th was
9 a.m.
9 a.m. Mm-hmm. And then Ms. McLean, you talked about screen time. Are you meaning that when the children are with Mr. Moses that they can't have any screen time?
Yes.
I'm going to decline that request.
Your Honor.
Yes, go ahead, Ms. Height.
I am technically no longer on this case because I filed my final report.
Okay.
I'm fine to stay off this case, but I would like to know if I'm going to be on, if I should be reappointed. I'm going to defer to the parties and Your Honor on that.
Mr. Zandy, Ms. McLean.
Whatever the court decides, it's fine with us.
And I can draft supplemental order to that initial GAL one, but I guess we gotta, the three of us confer about what we want that to look like with fees and such.
Yeah, and I don't recall what the parties did originally with that, but I would like to reappoint Ms. Height and approve that some additional time. I do think that again, with setting a review about 60 days out, I think it would be very helpful to the court to have your review of Rosen's recommendations and make any supplemental recommendations to the court.
Okay, Your Honor. Do you want it to be only related to that, or could I have a visit with the boys? Do you think that would be appropriate? I don't want to gum up the works, but I also would like to be able to give a clear report if I'm going to be reappointed.
I do think contact with the children, as would be done under an initial appointment, would make sense in this scenario.
Okay, thank you, Your Honor.
Thank
What are
you.
we thinking as far, well, Ms. Height can let us know as far as hours.
As far as hours. Okay, why don't I'll let the three of you communicate about
Sure.
that. If there isn't an agreement, then on December 6th, I can rule on that, but I'm guessing you all can figure that out. But if not, I'll deal with it on December 6th.
All right, thank
Very
you.
well.
Thank you.
Okay.
Your
Thank you.
Thank you all.